Hi, I'm Heather Quick with the Quick Law Group, Divorce and Family Law for Women. Today we're going to be talking about children and custody in a divorce. It's a really hot topic. People have so many questions about it. And I'm just going to give you three main things that you need to know about the custody of your children when you're going through a divorce. And the first thing we're going to talk about is what is the law in Florida in regards to children. So the first thing to know is it's called time sharing. But I know everybody thinks it's custody, and that's fine. And if your attorney says custody, then they might be a little out of date. So you want them to say time sharing. The law has been classified as time sharing for quite some time now. And that is to try to make it seem as if it's not such a harsh word as one parent gets the children and the other doesn't. And it still may feel like that, but the word is now time sharing. And as it implies, sharing time with your children. The courts are very clear. The child, they have a right to spend time with both parents. Now, traditionally, the mother and wife has always had the kids as the primary. And it's usually going to be some extreme circumstance when the mother either doesn't want the children, is unable to care for them, and the father takes care of them. That's really not the case anymore. And we can kind of go into that a little bit on all the things are, but the law right now is not 50-50. I have more people than you can imagine every day. Well, it's 50-50, and my husband said it's 50-50. It's not. Now, is it going that way? I think that it is, because I think that we've evolved as a society, and more fathers are more involved. They want more time with their children, and it's a way that I think, my opinion is that the courts kind of sometimes in the laws evolve. For so long, it was always the mother. A lot of fathers have really been active and to try to get the law changed. Now, that being said, I do believe that there is still a lot of gender bias, and all that the dad has to do is come in and say, hey, I want my kids, and everybody, bows down to him and thinks it's the greatest thing since sliced bread, when you've been doing all the work the whole time. And I recognize that as a mother myself, and my own beliefs, but the courts don't really listen to me, and the law is not catered after what I believe. But I understand how that feels. And we'll work through it, because it's really frustrating. And I know a lot of women who are really afraid, very afraid to even begin this process and go through a divorce because of that, what's the court going to do with my kids? And I recognize that. It's scary, but that's for a whole nother video on really, what you are doing for your children either way. But understand that the key factor, like the number one thing, is what's in the best interest of the children. And that's what the court cares about. That's what all the case law cares about. And that's really going to be the determining factor. So you're going to hear a lot, especially if you and your spouse are talking about divorce or fighting, unfortunately, or you have friends who've divorced, they talk about, well, it's 50-50. No, it's what's in the best interest of the children. And sometimes that may be. And the more contested it is, these things can go on for a long time. The longest I've had is probably 2 or 3 years related to the children, and it's very difficult on everybody involved. But there are several factors that the court considers, and many times we appoint an expert, which is kind of probably getting into the step number 2, which is really how do they figure it out. But the key that I really want you to know is, what does custody look like in Florida, and what is the law? Right now, as of the beginning of 2018, it's in the best interest of the child. Now, depending on what county and area of Florida you live in, there's going to be certain customs, there's going to be kind of guidelines that the courts tend to follow. So that being said, knowing, all right, and that's why it's so important when you talk to your attorney that they know what the norm is in the county, city you live in, because they're going to know, hey, Judge Smith tends to do this, Judge Brown does this, Judge Black does this, just kind of an overall thing. Now your facts may be different, and that gets into a whole very specific strategy and understanding of what you want to achieve. But basically, it's the best interest of your children, and understanding the courts are looking at, hey, you both parented and made these kids, they should really have time with both of you. So the second thing I wanted to talk about is, well, how do they figure that out? Well, that's the big point. How are they going to know what you guys have been doing for all these years, and now in a short period of time, you're going to have a stranger make a determination on how much time your children are going to spend with either parent? And I say that because it is serious. It's a big deal. And a lot of times we really work not only with our clients, but also we hire experts. So that's one way. We hire an expert. And the court will appoint them. It's called a social investigation. If you went through this many years ago, it was called a custody evaluation. But now it's a social investigation. Again, it's supposed to be a kinder, gentler term. It's a psychologist, generally, or a licensed clinical social worker. And they're gonna really talk to you, talk to your husband, talk to the children, and observe the interactions and issue a report that is gonna recommend to the court what they believe the time sharing arrangement should be. How should we implement a parenting plan? So, these are, yes, strangers coming in and making those decisions. And, one of the things, what do we look at? Well, there are several factors that have to be considered. So one may say, and I think it's just frequent and it's a problem for everybody, substance abuse. Whether it's drinking, drugs, prescription drugs, illegal drugs, alcohol, it's a problem. On both sides, frankly. And I have several mothers who have, overcome that, and we've really tried to get them in a plan so that it doesn't keep them from having time with their children. But, you'll have somebody say, well, he had a DUI. How do we deal with that? It's relevant depending on how long ago it happened. It's relevant if they have a problem and the court's looking at, well, how much time are they going to have with the child? Any crime is relevant, and I say that from a perspective of, okay, if it happened 20 years ago, the judge isn't going to care. You say, well, he got a disorderly conduct, he was 18 and drunk on the street, and now you're in your 30s. And that's a lot of common sense, but sometimes common sense isn't always there when you're going through a divorce. We understand that. So, and I'd rather you give us a lot of information and we'll help you kind of discern, okay, yes, this will work, this won't, this the court's gonna wanna know about. So substance abuse and any kind of anger, any violence, any of those issues, even if it's been a while, if there's ever a criminal conviction or any kind of treatment ordered, it could be relevant. It's very important. It's certainly important the age of the children. It used to be that the children always went to the mother, like under 2. That is not written in the law anymore, and so that can be very difficult for women to figure out, like, how am I gonna share, my young child with the father? And that's where having that social investigation, the psychologist, somebody there from a therapeutic standpoint, not the legal standpoint, but from a therapeutic standpoint, can say, hey, this is what's best for the child. And that's where the court is always going. So they look at those factors as far as both, parents' history, what's your work schedules? How is that going to impact your ability to care for the children? What kind of support do you have? Where are you living? What kind of environment is there? So all of those things come into play. A big thing that I definitely want to touch on and is how much you encourage the relationship of the father, your children's father with them. That's so important. Making disparaging remarks and bad mouthing your children's father is not a good idea at all, on any psychological level, and definitely not as a legal perspective. And I know you may think, oh, well, I know that in common sense, but in the heat of the moment, avoid texting and voicemails, because that's just really not a smart idea when you're going into litigation, because to see that text message blown up on a piece of paper and shown to the judge, or the voicemail played, I like it when it's in favor for my clients and it's, the husband made some stupid, drunk remark or said something ugly, but really don't like it as much when it's my client. But if you've done it, let us know so that we know ahead of time and we can work through it, because again, divorce is tough. Communicating is tough. There's a lot of anger, a lot of emotions. Very difficult when, children are brought into it, but it happens. So at least if you can be aware, and exercising constraint and taking the high road is something I talk about a lot, and it is tough, but it's worth it. And it's one of those, this is a marathon, not a sprint. trust us, like let's get through this, and depending on what your strategy is and what you want eventually, as far as, you know, what this time sharing arrangement is going to be with the children. And there are so many tools now just through the legal system and things they can order, like parenting coordination. You know, there's one that's like high conflict divorce, and you know, is it a magic, you know, wand or anything? No, but it does help. And there's a lot of tools that can be used to really try to make it easier for parents to communicate for the benefit of the children. Because really that's what the court cares about. So it's all about the kids, not about you. And same with him, it's not about him, it's about the kids. Now, with the impact of the time sharing, it does affect child support. And from, you know, my point of view, it really can drastically, when we go from, and I talk in terms of 60-40 to 50-50 or 70-30. Those are the percentages of overnight. That's how child support's calculated in the state of Florida, is how many overnights and how much each party makes. Those are the main significant indicators of how the child support's going to be calculated. So overnights do matter. And and the reason it matters is because if you think about it, if you're each have the children 50% of the time, you're housing them, feeding them, and clothing them 50% of the time. So it's going to affect child support based on the amount of overnights. And those are things that, you know, there are charts that you can find, I think, on online with the Florida statutes, but we can really plug in those numbers and compare different scenarios because there's so many things that go into that. And then alimony, which is separate from child support, but absolutely affects child support. So there's a lot that goes into there. It's kind of one of those things, you really don't know what you don't know. You got to come talk to us and let's evaluate where everything is. But the time sharing is determined before the child support is, because we need to know what is that arrangement going to be, and then we can calculate the amount of support. So the last thing I want to touch on, I talked about what it was, how they figured out, and then the last thing I want to touch on is when. You know, when does this get determined? So let's walk through a scenario. Guys have agreed to divorce, he's left the house. That's, you know, really an ideal situation, so you're not living in the same house during a divorce. Not always happens, but let's just say that's the scenario. So you go, okay, I'm just seeing you as an attorney. How do I come up with what this is going to be? This is new. It's difficult for the kids, and you really don't know what to do. Well, you know, let's just assume maybe your spouse, your husband is a little more savvy than you are and wants you to sign an agreement as to this is the way it's going to be. I advise you against that. You know, if you just don't know what you're signing, and is the court going to consider it? It probably will. So you're an adult, you're making a decision based on your children. You know, obviously if there is duress or threats, I mean, that's different, but generally speaking, I would avoid doing that. I would talk to an attorney first. Again, think about the few factors I talked about, the one being don't disparage the other party and don't withhold children. They're not property. I know we think of them, I mean, I say that, my kids, you know, you're mine, you belong to me, but they are humans, and when we're dealing with time sharing, as hard as it is, just try to remember that. And I just think that getting some advice, legal advice, as well as therapeutic advice is really gonna help. Because we all have different, you know, we're gonna have different perspective. But ideally we want you to be able to say, hey, I did what was the best interest of my children. And if you get yourself in a situation where you're in front of the judge, you just wanna be in that situation where you're not being called out and put in a position where the judge is angry because you refuse to let the children see their father, the father see their children, for anything other than just anger and spite and not evidence of any kind of danger to the children. And that's why it is a touchy situation. So you really need to seek counsel as soon as possible, because you may not know what to do. And hopefully it's a situation where, you know, you two are amicable and the children are are safe and they're, you know, your husband wants to take care of them, you guys can work things out. Even so, before you get anything in paper, let's really look at the long-term effects of that. But you want to, in the beginning of the process, one, don't sign anything, and don't make any just like blanket agreements, like this is what we're gonna do. I mean, you don't know how it's gonna be for the kids. Some things may be more time may be, you know, not good for them, and less time may not be good. You know, they may need more time, more frequent, depending on their age. Sometimes you have to have a little bit of flexibility. So that's why I say just don't try to come to this is exactly what we're doing. Try it and say, let's try this and see what works, so that we can make sure that we have that flexibility to do what's best for the kids. That's in the very beginning. You know, as we evolve through it, we try to do that. You're their parents. You know, it's hopeful the two of you can at least agree on something that's best for the kids. Most of the time that happens eventually. It's difficult sometimes in the beginning. But the main thing is, don't withhold children unless there's a danger or safety issue, and that kind of gets into a whole nother segment. But seek counsel so that decisions that you make aren't held against you. That's really what, you know, I want this to be, like helping you make the right decisions in the beginning, because sometimes a lot of stuff happens at the very beginning when people split, trying to figure things out, and they end up kind of getting stuck in a situation, in a schedule that they really didn't mean to happen. So seek advice so that you understand the implications of what you're doing, and give yourself the flexibility to see if this is working for your children. Because I mean, I've seen so many different arrangements, and it really depends on the ages of the children and a lot of other factors that really come into play. So if you have any questions or concerns, please reach out to us at the Quick Law Group. You can certainly comment and we will respond to you. Sometimes it's confidential, so if you want to comment and want to be reached, you can click to subscribe and contact our office either through the phone number or email, and we'll be happy to discuss this at more length with you so that you can really get to the right spot and all your questions answered. Thank you so much. Thank you for watching. Please like, comment, and subscribe, and give us a call at the Quick Law Group.